Today ends the second week in witness testimony in President Trump's criminal trial in New York. A once trusted member of Trump's inner circle took the stand. Trump faces 34 counts of falsifying business records.
So they really thought they had him this time. They actually thought they could print the labels and book the interviews and celebrate those 34 felonies like they were written in stone. But it is January 2026 and that stone is turning into sand. It is absolute comedy watching the Manhattan District Attorney realize that his big moment is being erased by a reality he didn't see coming. The backstop is here, folks. Behind the scenes, a federal eraser is moving toward the books, and that March 23rd deadline is the moment the trap finally snaps shut on this New York circus. It is all starting to crumble for the hive mind.
A district court in D.C. ruled against us on military readiness, meaning gender dysphoria, ruled against us. We appealed that to the circuit court and we won. The second we won, within minutes, Shannon, in California, they filed an identical lawsuit and we lost. So that's what we're up against. It's basically a game of whack-a-mole with these district court judges around the country who have a tremendous amount of power. They believe they do, but that's why we're appealing all of these cases, of course, up to the Supreme Court.
And then we have the star of the show. Who is the woman who testified and accidentally handed the win back to Donald Trump?
Hope Hicks, the former president's longtime aide and confidant, took the stand today, telling prosecutors she hadn't spoken to Trump in 2 years. Sitting 10 feet from him, Hicks said, "I'm really nervous."
I was very interested in what took place today.
Hicks detailed some of the tensest moments of the 2016 campaign and broke down in tears at one point. She described the chaos inside the campaign following the revelation of the Access Hollywood video weeks before the election, when Trump spoke in vulgar terms about groping women.
When you're a star, they let you do it.
Hicks testified she was very concerned about what it meant for his election chances.
Hope Hicks serves as a guide for the jurors to all of the operations surrounding Donald Trump. She knows each person, where they sat, what they did, and she is the person who therefore connects all of the dots.
In 2018, once Trump was president, Hicks said he spoke with her about Michael Cohen making payments to Stormy Daniels to protect him from a false allegation, which he said Cohen did out of the kindness of his own heart. Hicks testified that would have been out of character for Cohen, and Trump has denied any wrongdoing. Seen frequently at Trump's side, Hicks was one of the most loyal members of Trump's orbit, ascending from campaign press advisor to White House communications director.
Thank you all so much, and thank you, President Trump. I have stage fright, so.
She's great.
You have to love the irony of Hope Hicks being the one to end this. She was the White House communications director and she took the stand to help the prosecution, but she accidentally poisoned the entire case. Why? Because she talked about conversations she had with President Trump in the Oval Office. Under the new immunity rules, that is a total disaster for the left. It was a crisis they didn't see coming, and if you watch to the end, you will see exactly how this deletes every single charge. Now we look at the Second Circuit Court of Appeals, and the irony is just delicious. This panel has judges appointed by Obama and Biden, but they are already signaling that the state court went way too far against Trump. They didn't just open a door, they invited a total federal takeover of the case. They are forcing a re-examination of whether a local DA can weaponize official presidential acts in a state courtroom. It is absolute perfection watching these liberal appointees have to admit that the law actually applies to everyone even when they don't like the person involved. The core of this argument is evidentiary taint, because the Supreme Court was crystal clear that you cannot use the official duties of Donald Trump to prove a private crime. They used his tweets. They used his meetings. They used his federal ethics filings. And now the legal team for Trump is dissecting this trial like an autopsy. They are highlighting the Hope Hicks testimony and those checks signed at the Resolute desk. If even one official act was used to influence that jury, the entire 34-count structure is constitutionally poisoned. It has to be discarded like it never happened.
Donald Trump's defense team puts forward this argument that a former president should be held completely immune from prosecution for any of the acts that they performed while in office.
I feel that as a president, you have to have immunity. Very simple.
After a lower court rejected Trump's immunity claims, the former president appealed, and on July 1st, the Supreme Court gave him a sweeping amount of protection against criminal prosecution.
The court's very explicit about this. It lays out its framework by saying, quote, "The nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority, What the court is saying in this part is quite surprising. They're basically saying that nothing he does in terms of pressuring the Justice Department to investigate whoever he wants to investigate as president can ever be subject to criminal liability.
The High Court's opinion also says that Trump is entitled at a minimum to presumptive immunity from prosecution for all his official acts. However, a court could determine that some conduct, such as a campaign speech or fundraising, constitutes an unofficial act.
The Supreme Court says, quote, the president enjoys no immunity for his unofficial acts and not everything the president does is official, end quote. So a big question here is, when was President Trump acting in his official capacity as President of the United States versus when was he acting as candidate for re-election?
We will never concede. It doesn't happen. You don't concede when there's theft involved.
Do you think the Second Circuit will erase the counts before summer, or will this go all the way to the Supreme Court? Pick one and comment below right now because the comment section is probably already on fire. Remember how back in January 2025 Judge Merchan tried to be clever by giving President Trump an unconditional discharge?
The ruling sends the case back to Federal District Judge Tanya Chutkan in Washington.
The next step is for Judge Chutkan to engage in what we call fact-finding. She will now apply the Supreme Court's framework to the allegations to determine what is official versus unofficial conduct. If it is official conduct, is it absolutely immune? If it's not absolutely immune, is it presumptively immune? And if it's presumptively immune, could the government rebut the presumption? That's all a hodgepodge of very difficult legal questions. I think it's inconceivable that there will be a criminal trial before the election.
If Trump is elected to a second term, experts say he has several options to quash the case.
President Trump would be the head of the executive branch of the Justice Department. He could order the Justice Department just to stand down. He could say on day one, I have determined this was a witch hunt. President Trump could potentially try to issue a self-pardon. But that's more controversial, and even the Justice Department in the distant past has said that a president cannot pardon himself.
No jail and no fine and no nothing. It was a desperate move to keep this case away from the Supreme Court. Bragg is trying to argue there is no injury because there is no punishment. But the Second Circuit isn't buying the nonsense. They know that having a felon status on a sitting president is an unconstitutional burden that the federal government cannot allow for the man holding the office.
So, look, all I want to do is this. I just want to find 11,780 votes, which is one more than we have, because we won the state.
A court will have to rule on whether he was acting as president or not when he made that call.
The Supreme Court term that just ended included an extraordinary run of victories.
Well, this was a big one, wasn't it?
For the Trump administration.
The Supreme Court has delivered a monumental victory.
Most of that action took place on what lawyers call the court's emergency docket. When presidential administrations file these applications, they are almost always because some lower court judge has blocked one of their major initiatives. And on more than a dozen occasions, the administration raced to the court on issues like immigration, birthright citizenship, transgender rights, the independence of executive agencies. And in that emergency setting, the court generally gave them what they wanted. The volume is way out of proportion to earlier administrations. In just the first few months of the second Trump administration, they filed 19 emergency applications. That's the same as over 4 years of the Biden administration. And then if you go back a little bit longer, the comparison is astounding. Over 16 years, 8 of Barack Obama, 8 of George W. Bush, there were only collectively 8 emergency applications. We're used to thinking about the Supreme Court as a slow-moving, deliberative body. And that's true in most cases. The emergency docket is something else entirely. It jumps into the case on very thin briefs with minimal deliberation and gets decided in a matter of weeks with orders that contain very little reasoning and often none at all. The court likes to say that it's not political, but the emergency docket seemed to result in lots and lots of 6-3 decisions along partisan lines. When you look at the merits docket, the more traditional way the Supreme Court decides cases, the cases that were argued and where the court had a chance to really digest and consider them, the picture was mixed. The court decided 56 merits decisions this last term. Only 10 of them were 6-3, and only 6 of those split along partisan lines with the Republican appointees and the majority of the Democratic appointees in dissent. And that probably tells you that time is the court's friend, that if you give them a chance to consider and deliberate, they might be more apt to find common ground than on these emergency cases. It's true that these orders on emergency applications are temporary and provisional, and it's at least theoretically possible that it returns to the Supreme Court and they ultimately find that the challenge program was unlawful. But in all of that time, people will be kicked out of the military because they're transgender. People will be fired from executive agencies. And it's probably too late for a lot of those people.
This is where the federals take total control. Under the Supremacy Clause, a state cannot interfere with the operations of the federal government. By trying to brand the commander-in-chief a felon based on records from his first term, New York tried to put a leash on the presidency. But the federal courts are snapping that leash right now. This isn't just an appeal, folks, it is a jurisdictional seizure that ends the Manhattan case for good. And if the Second Circuit wavers, we have the ultimate backstop in the U.S. Supreme Court. They already laid the tracks with the 2024 immunity ruling. That 6-3 majority has already signaled they won't let state courts nibble away at the presidency. They see this as a threat to the office itself. If the lower courts don't erase these counts for Donald Trump, the High Court is expected to step in and declare the entire trial void. The March 23rd deadline is the wall they cannot climb over. We are watching the slow-motion erasure of the most publicized hit job in history. If you are enjoying the meltdown and you want to stay ahead of the March 23rd deadline, make sure you hit that notification bell and subscribe to Political Detox. We do the deep dives that the mainstream media is too terrified to touch. If you need more information on these three judges or the evidence from the start of the trial, click the link above to see how this started and where it is going next.